Hello and welcome to Absolute Trust Talk. I am Kirsten Howe. Today, I can't really say I'm the host because I have my associate attorney, Madison Gunn, here with me, and she's also been a host on this show. So we're just kind of co-hosts, I guess, and co-guests. We're covering it all together here. So Madison's here with me today. Madison, today, the day we are recording this is May 5th, Cinco de Mayo. That's probably not the day most people will hear it, but that's what's happening today for us. Is that a special day at all in your family? Do you do anything for Cinco de Mayo?
It's not special, like of cultural significance, but it is my mother-in-law Ernie's birthday today, and so that her birthday is Cinco de Mayo, and so we usually have some sort of celebration for her birthday.
Awesome.
Yeah.
And how old is she today? If you think she wouldn't mind us knowing.
She is 90 and going.
Awesome. Yeah. When you get to 90, you don't care if anybody knows how old
I
you are.
don't think so.
You're proud.
It's pride. Yeah.
You're proud. Yeah. So Cinco de Mayo's not ever been a big deal in our family. I mean, I didn't grow up in California. I never heard of Cinco de Mayo until I was out of college. But this week is Mother's Day, which is a big deal in our family. And I am looking forward to that. It's one of my 2 or 3 favorite days of the year because, your kids have to do whatever you want on Mother's Day. That's how it works in our family anyway. Enough of this tomfoolery. We got to get down to business. We have been doing a lot more trust administrations in the last few years than we've ever done before at Absolute Trust Counsel. So trust administration, just so everybody knows, is the work that has to be done when someone who has a trust dies. There's legal work that has to be done, and we've been doing a lot of that. Obvious reasons would be COVID. Of course, a lot more people have died in the last few years. It's also the euphemism is our practice is maturing, which means, the longer you've been doing the work that we do, the more clients you have who just died. That just is a fact. And then other attorneys retiring, so we get their clients. That happens too. But yeah, for a variety of reasons, we've been doing a lot. And so we're seeing a lot of failures. And Madison and I are kind of on a personal quest to educate the whole world so you can avoid the failures that we see from time to time. So that's what this episode is about. We've done other episodes about this topic, and we've got an endless supply of failures that we could talk about. So we're going to do it again today. So Madison, let's talk about some of those unfortunate failures. What's the first thing on your mind today?
Yeah, what we've seen, and even just recently, there's been a little bit of an influx of it, is federal assets or assets governed by the federal government or, registered with them. So a lot of that is difficult because there is no federal probate code that you can go off of. The probate codes are all portioned to the states. So California has their own, and the federal government doesn't have to follow it. So for all of those assets, we have to follow their rules, which makes things not go as smoothly as everyone else might.
Yeah. Okay. So, and there are several kinds of assets that are registered by the federal government rather than the state of California. But I think the most common one that we see, and you'll understand why in a few minutes, the most common one we see is the United States savings bonds.
Yeah. And way to go for not cashing those in anyway. But that's usually the problem. And there's 2 kinds. There's the paper ones that we all got, when we graduated high school or, in our stockings or whatever that our grandparents gave us that we probably cashed in. And then there are the ones that are electronically registered, the modern ones, with Treasury Direct, which is the federal government's implementation of U.S. savings bonds. So you have to follow their procedure when somebody dies. You can't necessarily just do, the California way.
Right. Okay. And so When the bond owner dies, what you do kind of depends on, is it a paper bond or is it an electronic bond? But it also depends on actually how the bond owner owned the bond, what the titling was there.
Yeah. So you could have two owners, a husband and wife own the bond. When the first spouse dies, the second spouse can just submit a death certificate, fill out whatever paperwork they want, and it's theirs. Most of the time, people don't even do that. It just still has both spouses' name on it. And then maybe they'll cash it and, maybe they won't. If it's just one person's name on it, it's if they have a beneficiary and they die, it goes to the beneficiary. If they don't have a beneficiary, then what? And the most common thing we see is a husband and wife, and no one's ever done anything, and both spouses have now died.
Yeah. And that gets difficult when there's no remaining joint owner and there's no death beneficiary on the bond. If this were a California asset, something simple like a bank account, we would just do what's called a small estate affidavit. And that's something that the probate code in California allows us to do. But again, federal government.
Yeah. They're going to ask you for letters or letters testamentary. And, this is a nice big, alert, red flag. It's a trap. If anyone ever asks you for letters or letters testamentary, that means you have to open a probate.
Right.
Because letters are what the probate court issues the executor or personal representative to give them authorization to get the assets of the deceased persons in their name.
Right. So even though it's maybe a small amount in the bond, not enough to trigger a probate, we still have to do a probate because that's what the federal government wants. And that's the only way. We got to satisfy them to get that bond. Yeah.
And even the judges will be like, why are you doing a probate for $5,000? And I'm like, well, don't ask me. I didn't write the law. I'm just doing what I was told I have to do in order to get it.
Yeah. Yeah. So that can be very frustrating to our clients when they find out, my mom had a trust. We did everything right. Oops, we still have to do a probate. That's very frustrating. That's like one of my least favorite conversations with clients is when I have to tell them that. And it's a little uncomfortable. Okay, so we avoid this problem by what?
By making sure you have current pay on death beneficiaries. Most common, I would presume, would be to transfer that into the online account if you have paper bonds, so that it's easy to change your beneficiaries.
Right.
So you're not having to go into a bank, get a form, file it with the government, hope they get it and process it, and hope you get a response, confirmation.
Right. Or alternatively, you could change the titling on the bonds that you own so that your trust owns them.
Right.
Yeah. And then you don't have that probate problem. Just trust solve everything. Just if you remember nothing else from today.
Yes. Even if you keep your beneficiaries up to date, that doesn't mean everybody dies in order.
Right. Yeah. That's the problem with doing estate planning by beneficiary designation. You can't always control things. Whereas with a trust, you can.
Yeah. Or if minors are inheriting, which we'll talk about.
Right. Just a little bit. That's another whole quagmire. Okay. So we were saying, when an asset is registered with the federal government, that can be a problem. So that's I'm sorry. Is that Rocco or Chef?
It's Rocco. Amazon's here. Sorry.
Okay. It'll be done in a second.
Yeah.
That's okay. We'll probably have a cat tail across the screen in a minute. Okay. So the other asset that is registered exclusively with the federal government, planes and boats. So let's talk about that. Let's talk about planes, because that is exclusive to the federal government.
Yes. So all planes have to be registered with the FAA, or the Federal Aviation Administration. And that's how they get their tail numbers, and they're all registered in that way. So there is no, just like the US savings bond, there is no way. It's not the California DMV. It's not some state agency. It is the FAA. So it's a mandatory. Everybody has to know, they have to know who's in the air. And then the other one, which we see quite a bit in the Bay Area because we have a lot of waterways, are boats.
Right.
And there's two ways to register boats. There's the DMV, the California DMV, or the Coast Guard. And I think, and I'm not certain, so I'm not going to quote anything, is a lot of times the length of the boat or the size of the boat has to do with the benefit of registering as in the with the Coast Guard versus the DMV.
Yeah, I think the boat has to be a certain size, and then you have the option of registering with the Coast Guard, but you're not required to, I don't think. But there definitely are advantages, I guess, having to do with if you're going to be traveling in international waters, then you would want to be registered with the Coast Guard because there are benefits to doing that. But anyway, that's not the topic here. It's just here we are. You know, you've got a plane or a boat registered with the Coast Guard or the FAA. You have the same problem, right?
Yeah. They're either going to have their own paperwork or they're going to require, and a lot of times their own paperwork still requires it to be signed by the
executor,
personal administrator, or the executor, which means, you know, just because you're named in someone's will doesn't automatically make you the executor. Like my will could say, I appoint Kirsten as my executor. That doesn't mean she has the executor authority that in order to sign paperwork, she has to actually be appointed by the court with those letters testamentary.
Right. So again, these are assets that we don't see quite as often in our practice because, you know, you have to have a ton of money to own a plane, I think. But how do we solve these problems, or how do we avoid these problems?
Yeah, so it's always to title them in the name of your trust. Or I've seen in some cases with airplanes, people co-own them because you have to have a lot of money to own an airplane. So they'll create like an LLC, but you still want to put that in your trust. You still want to have your trust own own your share of the LLC that you could, so it's still all kind of dials back to, goes back to having it titled in your trust. And then that avoids all the issues of requiring probate.
Yeah. Okay. All right. So now we've been talking about problems having to do with particular assets. Now we're going to focus for a bit on problems having to do with a particular beneficiary. Madison, you want to?
Yeah. So we've run into this a little bit recently where minors have been named as beneficiaries of particular assets. Most of the time people set up a trust and have their children or a minor child or niece or nephew named. And that's okay because the trust says what to do if there's a minor. Because, minors can't sign contracts. They can't sign checks. They can't, direct banks to do things. Right. So, having the trust be in place, allows there to be an alternate disposition. So with situations like a retirement account, that is in required mandatory distributions, or required minimum distributions, those are all self-directed. So when you get an RMD, when you hit 72 and you have or if you've already hit 70 and a half and it was prior to the Secure Act, and you're required to take out that minimum distribution, but you have to request it. They don't just automatically do it for you.
Right.
They require you to do it, and then you have to do it yourself. And if you don't, then you get a penalty for not doing it. But when a minor inherits it, they have to continue taking out those RMDs, and a minor can't call the bank and say, okay, send me my $60,000 check.
It's time for my RMD. And they can't really open a bank account to transfer the money into either. So minors legally can't get assets like that. So what happens? What do we?
So the banks or the custodians of the retirement accounts require us to file a guardianship, or for that minor to have a guardian.
Right.
That doesn't mean your parent. It's, again, like letters. It's a trap. It's a trick. It means you need a piece of paper that says you are the guardian of the estate, which means you're in charge of their money until they turn 18.
Yeah. And I think a lot of people are surprised to be aware or to hear that, because you think if you're the parent of a minor child, you are their guardian. And that's true. you are the guardian of their person.
Right.
But here we're making the distinction, guardian of the estate. Your minor child doesn't have a guardian of the estate until a judge says they do.
Yeah.
So
And
you've got to actually go make that happen, even if
yeah.
you're the parent. Yeah.
And if it's like, a small cash amount, you might not need to go obtain a guardianship. You might be able to create, an account for the benefit of the minor at the bank,
Right.
and they'll let you do that. The problem is every bank, every financial company, they're all different.
They do it their own way.
They're all different. Some might require it, some might not. But if one requires it, you have to do it for all. So if they're inheriting 3 IRAs from 3 different custodians, one's, I don't know, Schwab, one's Fidelity, if one of those requires a guardianship, they all have to fall under the guardianship. You can't just really pick and choose.
It. Yeah, you can't just open up a uniform transfer to minors act account. Yeah.
Right.
Okay. Yeah. So I think a lot of people, and we know this from working with our clients, they're surprised to learn that they are not the legal guardian of their children's money. and that's a big detour in a trust administration. Okay. All of a sudden we're going to court. We're getting the parents to be the guardian. Yeah.
It's right up there with an incapacitated adult inheriting a bunch of money without a special needs trust.
Right. Okay. So the way to avoid this problem
would be to name the trust as the beneficiary of the retirement account. And you can name the trust and adult beneficiaries. It doesn't mean that you have to put it all in the trust, but you can put the minor share into the trust.
Yeah. And then you can change that when the child is over the age of 18. You can go back and change the beneficiary on your retirement accounts. It's not set in stone. You can always change that. So, because that might not be the best outcome.
Yeah, and you can wait until they're whatever age you think they should inherit. If you don't want them to all of a sudden take $1 million IRA at 18,
Yeah, you can say, okay, we're waiting till you're 30 and then we'll change the beneficiary. Yeah, you can do that. Okay. So as you said, we talk about, it's a similar problem when a disabled person inherits an asset like that. It's only a problem if the disabled person in question is receiving some kind of needs-based government benefit.
Right.
And we've talked about that, I think, in other episodes. Episode 41, I think we have discussed this problem of what do you do when someone who's receiving SSI, for example, or someone who's on Medi-Cal suddenly gets an inheritance of some sort. How can we fix that problem? So we're not going to go into a lot of detail about that, but it is a problem. It can be fixed, but it always costs more money to fix problems than to avoid them.
Yeah.
And so how do we avoid this problem?
It's putting the trust as the beneficiary. I mean, it goes up there with, even though you can avoid certain situations, if someone is on public benefits, what if they're incapacitated and not on public benefits? They can't direct an RMD either, like a minor can't. So it's the same.
That's true. Yeah.
I think what the big question, or the bigger question is, you have to think about your beneficiaries and plan for them, even though you're planning for yourself at the same time. But using the trust as the main vehicle avoids all of those problems: conservatorship, guardianship, conservatorship to get a special needs trust, all of that stuff that it could compound into court case after court case and, thousands of dollars.
Yeah. Yeah. That's when the trust administration really goes sideways, is when we have to start doing a conservatorship and then a special needs trust on top of that. And
well, and it's hard on people. I mean, a trust administration is hard enough. What if they're administering their parents' trust? They're grieving. They're having to administer a trust, which is not a pleasant job, even in good times.
It's a terrible.
And now you have to file for a guardianship of your own child or a conservatorship of your sibling because your parent didn't
plan well.
Yeah. So it's like, now there's just way too many emotions and it's not pleasant.
Yeah, and too much responsibility, and it's stressful. Yeah, it is stressful. So plan ahead. Think about who your beneficiaries are and what will happen if this money comes to them. And sometimes people die out of order, and that's, you know, unfortunate, but you got to kind of think through all of that as well. Because sometimes, you know, we have a special needs person, someone on government benefits who wasn't on government benefits at the time the trust was originally written. So people, keep it up to date is the other overarching theme for today. And so for that situation, you want to talk about how you can have a just in case to save that situation.
Yeah. So I don't know about most attorneys, but for us, all of our trusts have that provision in there. It's a whole article about what happens if a minor inherits, or what happens if they're underage to whatever age you get to designate is underage, or if a special needs person, you know, as defined, is a beneficiary. And so it does allow for some flexibility. It's not as great as a standalone special needs trust that everybody can leave something to Timmy, you know, in that trust, but it still avoids the need for court. It can still avoid that.
It will save the situation. Yeah. So yeah, we put those into all of our trusts just in case.
Yeah. Because I mean, you might not be leaving anything to a minor, but when people die out of order, then you don't know.
You're suddenly leaving something to a minor or to a special needs person. Yeah. Okay. Let's look at our questions. We always get a question or two. And I'm going to scan back. Okay, here's one. If a minor child needs a guardian of the estate and there are two parents, who will the court appoint?
Well, usually when you file the petition, you would choose one parent, or it could be both as co-guardians, although, as we've probably discussed in a previous episode, having two people be anything in a court proceeding can be a logistical nightmare. It's not, you know, if you agree on everything, that's okay, but the banks sometimes make you jump through extra hoops. So you could petition together, or one or the other. And if for some reason you're adverse to each other, mom and dad aren't together, and they're both petitioning, then good luck, and that's up to the judge.
Yeah, that's an unfortunate situation if the parents are divorced and they each want to be the guardian, because the judge is statutorily supposed to give some deference or some preference to the parents. But when you have both parents sort of fighting it out in the courtroom, that's when it gets expensive, even more expensive. Yeah.
And I'm sure it's frowned upon if they're spending that child's money to fight that out in court.
That's a good point. You're probably going to have to pay your own attorney fees.
The judge is not going to allow that, most likely.
Yeah, that's a good point. So anyway, okay. Another question. Okay, this is about U.S. savings bonds. Can I just add my child as a co-owner of my U.S. savings bonds? Madison, do you want to talk about that?
Sure. This is combining all the issues in one question. You can. There's nothing legally stopping you from doing that. But if you die and they're still a minor, they are not going to be able to access that savings bond. They're going to have a guardianship filed on their behalf of their estate. And they cannot cash that in at all until they're a minor or an adult. Sorry.
Right.
Also, that's an asset for both of you. So if you both own the asset, which we've covered again in another thing, adding your kids onto your accounts, you know, if they're a special needs person, and that's now an asset that's counted against them. If there's any needs-based benefits, they get into a fender bender, that's an asset. Yeah. I mean, I'm not thinking people have hundreds of thousands in savings bonds, but I don't know. You could. So it's not the ideal situation. You could just add your child as a beneficiary on the savings bond, or you can put it in your trust.
Yeah. So best is put it in your trust. Next would be add them as a death beneficiary, not as a co-owner. for all of the reasons that adding your child, it's also a tax issue. If you add someone onto an asset, you've just made a gift to them.
Right.
And depending on the size of the gift, you got to file a gift tax return. So, that's usually should be your last choice. We don't recommend it. Okay, I got one more question about savings bonds. So how do I change the title on my U.S. savings bonds to my trust?
Yeah. So there's a form called the FS 4000, and you would fill that out and follow the directions. And you can find that at treasurydirect.gov, G-O-V.
Yeah. And that form, I looked at it recently. It's the first couple of pages of it is more like if you're trying to do this is the form to use. If you're trying to do this, fill out part B and C of this form. So it's very, very helpful.
Like all IRS.
All you need to do is look at that form. Yeah. And they surprisingly helpful for the federal government. But anyway.
Yeah. Don't skip over any type of those in fine print instructional forms on IRS forms or Treasury forms. They usually have all the answers.
That's right. Yeah. In the instructions, they give you what you need to know. Okay. I think that's the end of our questions. Thank you all for being here with us. Madison, thanks again. Great job as always. Madison actually is going to host our next episode, I think, by herself. So those of you who are regular listeners, tune in next time in a couple of weeks. And we both look forward to connecting with you. Thanks for being here. Bye.
Thank you.
Thank you for joining us today for another episode of Absolute Trust Talk Live. If you enjoyed listening in, then don't forget to subscribe. You can find us on Apple Podcasts or wherever you may listen by searching Absolute Trust Talk. While you're there, we would also love for you to leave us a review. And then why not share your favorite episodes with family, friends, or colleagues too? You can find all of our shows and corresponding show notes by visiting absolutetrustcouncil.com. You'll also find a variety of other free resources, including our ebooks, videos, blogs, presentations, and more. If you need help with your estate planning or administration, we also offer a free discovery call to help get the process started. You can find more information on booking your session by visiting absolutetrustcouncil.com/scheduling. Don't forget to keep an eye out for our next live episode in 2 weeks. If you join us for the broadcast, you can submit questions during the show. But if not, don't worry. You can always get in touch with us by sending a quick message to info@absolutetrustcouncil.com. Thanks again for listening. We'll see you soon.